Jai Hind everyone. Today in the lecture series of Constitution of India Law in Engineering, I am going to talk about the fundamental rights and the DPSP policies. So fundamental rights are the basic rights which is given or mentioned in the Indian Constitution, and our Indian Constitution is enshrined with the fundamental rights. And these fundamental rights are the constitutional rights and these are the basic rights. So let's begin with the fundamental rights in detail. So fundamental rights are essential human rights that are offered to every citizen irrespective of caste, race, creed, place of birth, religion or gender. So part 3rd of our Indian Constitution enshrined with fundamental rights. So these basic rights are applicable for all, and our Indian Constitution does not discriminate on the basis of caste, race, creed, place of birth, religion or gender. So these fundamental rights are applicable for Indians, and some fundamental rights are also applicable for the foreigners or who are living in India. So these are equal to freedoms, and these rights are essential for personal good and the society at a large. These fundamental rights are enforceable by the court. Enforceable means, like, if there is any violation of fundamental rights or the parliament or the government are not able to enforce the fundamental rights, then any citizen can approach the higher court of India, which is Supreme Court, to enforcement of the fundamental rights. Now we will discuss about what are the basic features of fundamental rights. So fundamental rights are different from ordinary legal rights in the manner in which they are enforced. If legal right is violated, the aggrieved person can directly approach the Supreme Court, that I have already mentioned. A person can directly approach the Higher Court of India. It means a person who feel like there is a violation of fundamental right in the state, or the government is not able to enforce the fundamental right, he can bypass the lower courts like the civil courts or the high courts and can directly approach the Supreme Court of India. Now second point is, some of the fundamental rights are available to all citizens, while the rest for all the person, whether the person is citizen of India or whether the person is citizen of not citizen of India. Fundamental rights are not absolute rights, they have reasonable restrictions. Like I am saying, the fundamental rights are applicable to all, but there are some restrictions, like in case of national emergency, the government can declare national emergency in some cases and can restrict some of the rights. But the Article 20 and 21 does not, we can say, does not restrict after the constitutional amendment of 44th. And this constitutional amendment 44th was declared in 1978, and after this the Article 20 and 21 the government cannot restrict. Next is, they are justiciable, implying they are enforceable by courts. People can approach the Supreme Court directly in case of violation of fundamental rights. Fundamental rights can be amended by the Parliament by a constitutional amendment, but only if the amendment does not alter the basic structure of the Constitution. It means there are several cases. Earlier there was a provision that fundamental rights cannot be amended, but now there is a case, the case was the case of Nanda Bharati versus State of Kerala, and according to this case the fundamental rights can be amended, but the basic structure of the Constitution cannot be amended. Next, fundamental rights can be suspended, as I have already mentioned, during a national emergency, but the rights guaranteed under Article 20 and 21. What is Article 20? The Article 20 is problem in respect of conviction for offence, and the Article 21 is protection of life and liberty. So these fundamental rights cannot be amended. Next, the application of fundamental rights can be restricted in any area which has been placed under martial law or military rule. So some of the fundamental rights the government can restrict, like if there is any martial law implemented in the state for that particular, for some reason, or if there is any military rule, like there is some emergency kind of situation or war-like situation. So some of the fundamental rights can be restricted. Now there are 6 fundamental rights. Earlier there was 7 fundamental rights, and the right of property also mentioned in the fundamental rights. But now there are only 6 fundamental rights, that is the right to equality, the right to freedom, the right to freedom from exploitation, the right to freedom of religion, cultural and educational rights, and the right to constitutional remedies. So let's move on the next slide and discuss one by one the each fundamental right. Number 1 is right to equality. The right to equality is mentioned in Article 14 to 18. So Article 14 to 18 ensure the equality in the state. Like there should be no discrimination. The government cannot discriminate, or any person, any body, any authority cannot discriminate any person on the basis of religion, gender, caste, race, or place of birth. And in case of the employment opportunities, there is a right that employment opportunity should not also be biased, but in some cases there are, like the government discriminate in some cases, like there are some reservation quotas and some other cases, but right to equality must be ensured in the state, and this ensurety is given by the right to equality in Article 14 to 18. Next is right to freedom. Right to freedom is a fundamental right which is mentioned in Article 19 to 22. So this is an important fundamental right, and according to this, every person can live their life with dignity, and for this reason the right to freedom is an important article, which is Article 19 and 21. So under this article there are some provision, that is freedom of speech and expression, like everybody is having freedom of speech and expression, like everybody can express their views, everybody can express themselves in the society. Freedom of assembly without arms. Arms are prohibited in India, like person cannot use arms but can assemble anywhere for any purpose, like the person can associate with any person, the person can assemble to propagate their religion, to influence other person, to make some unions, to make some trade unions and some other unions, but they can assemble but without arms, because our constitution or our Indian law prohibit of having arms. Next is freedom of association or union or cooperative societies. Next, freedom to move freely throughout the territory of India. Like the Indian constitution cannot do not restrict anyone to move any part of the country. Any person can move in any part or any territory of the country or state. Next, freedom to reside in any part of the country. Like our Indian constitution does not restrict any person to reside in any part of the country. The person can live or move freely in any part of the country. Next, right to practice and any profession or carry any occupation. Like any person, every person or every citizen of India have the right to practice any profession, whatever he wants to, like to join any organization, like in private organization or government organization, he can practice any profession or can carry on any occupation. So right to freedom enshrined with all the freedom which a person should have to live a dignified life in the country. Next is the number 3 is the right against exploitation. Right against exploitation is a third fundamental right, and which is mentioned in Article 23 to 24. So this article is basically specifically for the human trafficking or for the child labor. Like our Indian constitution prohibit the employment of the children who is living who is under the age of 14 and working in some in any condition. So our Indian constitution prohibit the employment or prohibit the child labor. So to prevent the human trafficking or to prevent the exploitation against the child labor, this fundamental right again is very important, and the right implies the prohibition of human trafficking, begar and other term of forced employment. Like if the working condition is not good and if the employer is exploiting any person or any employee, so this particular fundamental right provides this opportunity, like if there is any condition arise and the person can easily approach the High Court of India, which is Supreme Court. Next fundamental right is right to freedom of religion. So right to freedom of religion, which is mentioned in Article 25 to 28. And India, we can say India is a very diverse country, and there are so many religions, so many castes we can see all around. So our Indian constitution, or this was again, I can mention the vision of the constitution framers, like there should be a freedom to every person, then they can practice or profess any religion, they can propagate any religion. But yes, they cannot force someone uh, to join that particular religion or to adopt that particular religion, but they can influence anyone, they can motivate anyone. Yes, they cannot force anyone. So it indicates the secular nature of our country. Uh, if we see the features of our Indian constitution, and this is a very important point, it is again mentioned in the preamble as well, like India is a secular country and we should respect all religions. So every person, if any person is want to live a dignified life, so there should be a freedom to profess any religion or propagate any religion. But the state means like the government should not have any religion. An individual person can have a religion or practice any religion, but because I have mentioned the secular nature of Indian polity or the secular nature of the government, so the state cannot practice any religion. The state or the government cannot propagate any religion, they cannot promote any religion, they cannot influence any religion. So this particular fundamental right gives a kind of faith or a kind of we can say a diverse nature of our country. Next is cultural and educational rights. So cultural and educational right is mentioned in Article 29 to 30. So this particular right is to facilitate the educational rights or to protect the cultural rights of the Indian citizens. So educational right again is a fundamental right, but now is a constitutional right as well. Like the basic education is, we can see in our Indian constitution, the basic education is compulsory in India. Like the basic education we talk about, it is every child right. Like, every child should have at least a basic education, and to protect the cultural right as well, like to protect the monuments and to respect the culture of every religion or to respect the culture of every citizen. So this particular fundamental right is again important, and this also protect the religious rights, cultural rights, linguistics rights. Like we have cultural differences, we have language differences, we have other type of differences, and this particular fundamental rights also provides the opportunity to respect the culture and heritage of our country, because our culture is diverse, our heritage is diverse, the linguistics are different. So and to protect the rights of the minority class as well, like there's so many classes which are in minority, and to protect those rights, it is again important to establish the cultural education right in the state. Next and the last fundamental right is the right to constitutional remedy. This is a right which is given to Indian citizens for they can approach the High Court of India, which is Supreme Court. Like as I have mentioned, like if there is any violation of fundamental rights in the state, so this gives an opportunity to any person that they can approach the High Court of India, they can directly go to the court, they can bypass the lower courts, and they can approach the court and ask to enforcement of the fundamental rights. And in the right to constitutional remedies, the writs can be issued by the Supreme Court in case of the violation of fundamental rights. Like there are so many writs which Supreme Court can enforce in case of violation of fundamental rights, like habeas corpus is a writ, the mandamus is a writ in case of the violation of fundamental rights, and the Supreme Court can issue those writs. So the writs are, I would like to mention about writs, although writs is again a very long or wide topic, we will discuss it later on. But if we talk about the writs is a constitutional remedies. What is constitutional remedy? A constitutional remedy to protect the fundamental rights. So if there is any violation of fundamental rights in the state, then In that case, a Supreme Court can issue a writ. Now the question is, in my when I started this lecture, I told that there are total 6 fundamental rights, but earlier there was 7 fundamental rights. So the 7 fundamental right was the right to property. Now the 7th fundamental right is not a fundamental right anymore. It is a constitutional right, and the right was deleted from the list of fundamental rights. So what was the reason for deleting this particular fundamental right from the fundamental rights, and now it has become the constitutional right? So this was because the right proved that there was some hindrances toward the socialism and redistributing the wealth and property. So a citizen right to own a property, it can be a constitutional right, and but it cannot be a fundamental rights. So the state cannot take possession of it without following any procedure or authority of law. So right to property for that reason is no longer a fundamental right, it is a constitutional right, and now it is mentioned in Article 300A. Now there are some fundamental rights which are available only for citizens of India, not for foreigners. That I have already explained. There's so many, like all 6 fundamental rights are applicable to all, but few fundamental rights are not applicable to foreigners, like the person who is living in our country, the person who is not technically the citizen of India. So there is a list of these fundamental rights which is available only for the citizen of India, not for the foreigners. So number 1 is the prohibition of discrimination on grounds of race, religion, caste or gender or birthplace, which is mentioned in Article 15. Equal opportunity in matter of public employment, like public employment cannot be offered to the foreigners in every case. So we can say this particular act is only available for the citizen of India. Protection of freedom, which is again Article 19, like whenever any person who came to India or to visit India for the purpose of visit, or so there's no freedom at all, like they cannot roam around like in all the states. Sometimes a state or a particular region can restrict any foreigner to freely roam in any state. Speech and expression is a fundamental right, and which is a very important right, which is which is mentioned in our Indian Constitution. But in case of speech and expression, yes, it is there for only to the citizen of India, and in some cases it is not applicable on the foreigners. Association, assembly, like a person who is coming to India, they can associate with anyone, they can make associations, but there are some association which is again restricted by the government, so they cannot associate or assemble anywhere because they have a kind of visa or some they need some other papers to assemble or associate some other persons, so they need permission for the government to do so. Movement, residence, like a residency cannot always offer to the foreigners as well, like a person who is coming to India for a short period of time, the residency cannot be offered to that particular person. In some cases there's some other criterias or different criterias, and in that case a residency can be offered to that person. Profession, like I have already mentioned, like a person or a citizen of India can can choose any profession or can start any business or can join any organization. But in case of the foreigners, they don't have right to join any kind of employment in the country. In some cases they can join employment, but in some cases they need some kind of permission. Protection of culture, language and script of the fundamental rights, which is mentioned in Article 29. So the fundamental rights like the protection of culture and language, so Indian Constitution we can say cannot expect the foreigners for the protection or for the establishment of these particular rights. The right of minority, again this act also applicable to the citizen of India only, not to the foreigners. So I have completed the topic of fundamental rights. So we have discussed about the fundamental rights, like they are enforceable by the courts, they are justiciable by the courts. But in case of the directive principle of state policies, so directive principle of state policy is known as DPSP policies, and they are not justiciable by the court. What is the meaning of justiciable or enforceable? Means, as I have already mentioned, in case of the fundamental rights, if there is any violation of fundamental rights, so any person can approach the High Court of India, or they can seek the constitutional remedies. But in case of the directive principle of state policy, they are not justiciable by the court. They are mere the guidelines which is mentioned in the Indian Constitution for the for better governance, we can say. So DPSP policies, if we talk about the DPSP policies are mentioned in Article 35 to 21 and Article 35 to 51. So Supreme Committee in 1945 suggested two categories of individual rights. One is being justiciable, as I've said, and other being non-justiciable. So fundamental right we can categorize in justiciable, and the non-justiciables are the DPSP policies. So some of the students always ask this particular question, like, so if the DPSP policies are not enforceable by the court, then why the government will follow the directive principle of state policy? These are the guidelines. Yes, they cannot enforceable, but it is the duty of the government. It is the duty of the government to follow the DPSP policies or these guidelines, because earlier when the constitution was framed, the vision of the constitution framers to protect some of the rights or to give some of the rights, but they cannot enforce all the rights legally, because the country was not in the position to enforce all the rights as a justiciable. So for that reason, directive principle of state policy is non-justiciable in nature. Like if we talk about the right to education. Right to education, earlier it was only mentioned in the DPSP policies earlier when our constitution was framed, but now it is a fundamental right, and it is again a constitutional right. Like it is a every child right to educate ourselves. So this is again a constitutional right, and the directive principle of state policy, it is also again mentioned in the directive principle of state policy. It is again mentioned in the fundamental rights as well. So therein instrument of instruction which are enumerated in the Government of India Act 1935, which tell us about the directive principle of state policy, and they seek to establish economic and social democracy in the country. DPSP are ideas which are not enforceable by the court. Like if there is any violation, like if any government violate the DPSP policies and they say like we are not going to follow the DPSP policies and procedures and the follow-ups, so nobody can question on them. So if the directive principle policy originally cannot be classified, but to classify or to describe more, so I have classified the DPSP policies into three parts, that is socialistic principles, Gandhian principles, and liberal intellectual principles. So if we talk about the preamble, like preamble is a basic essence of our Indian Constitution, although preamble is a different topic, but I can tell you some objectives of preamble so that I can easily explain about the directive principle of state policy. So what is the preamble? Preamble is essence of Indian Constitution, or we can say it is a summary of our Indian Constitution. So, and if we talk about what are the vision or objective of the preamble, the vision or objective of the preamble is to provide social justice, to provide economic justice, and to provide political justice to the people of India. So as I have already described about the fundamental rights, so fundamental rights always protect the political rights. They do not protect the social and economic rights, but the directive principle and state policy basically focus on all three, like to protect the political rights, to protect the social rights, or to give social justice to the people who are living in India, and to provide economic justice to the people who are living in India. So we can say, as I said, like the focus on the vision of the preamble, or the objective of the preamble, like to give a social justice, or to provide economic justice, and to provide the political justice. But if we in depth we study the directive principle of state policy, we can see it provides the basic guidelines specifically for the social justice and the economic justice. So I will discuss all the three classification in detail, so that we can easily get to know like how the DPSP policies provide the guidelines on the social justice and the economic justice. So the classification are the socialistic principles, the Gandhian principles, and the liberal intellectual principles. What are the objects, like main features of the DPSP policies? So as I have mentioned, the fundamental rights are mentioned in part 3rd of our Indian Constitution, but our Indian Constitution is enshrined the DPSP policies in part 4th. Like all the classification, all the three classification mentioned in the Indian Constitution, the part 4th of our Indian Constitution. So part 4th of our Indian Constitution contains certain principles, that is called directive principle of state policy, which are the fundamental rights. And these fundamental rights, as I've already mentioned, is for the better governance in the country, and the state is under duty to apply these principles in making law. Number 2, DPSP are not enforceable by court. I have mentioning again and again, like the fundamental rights are enforceable by the court, but the DPSP policies are not enforceable by the court. DPSP bears a close resemblance to the directive principles of Indian Constitution. So DPSP policy we have influenced with the Irish Constitution, and we have taken, or I must say borrowed the directive principles or these guidelines from the Irish constitutions. The fundamental rights we have taken from the US Constitution. So why I am saying this, like we have borrowed these policies, or we have taken from this, because we have borrowed this, because, or we can say we have influenced by this. We have taken it, we cannot exactly copy paste it, but we have taken some of the references and mentioned it in our Indian Constitution. So DPSP lay down the objectives or goals which the state should try to impose certain obligation on the state to take positive action, and to protect the democracy and to establish a welfare state. Next, these principles are used to consider reasonable restrictions on the fundamental rights, and it is also useful for statutory interpretations. Now, what are the basic difference of fundamental rights and directive principle of state policies? Although I've already differentiate the fundamental rights and directive principle state policies, but I will quickly go through the differentiation. Number 1 is fundamental rights are incorporated in part 3rd of Indian Constitution, and DPSP are incorporated in the part 4th of our Indian Constitution. Number 2, fundamental rights are enforceable through court of law, like they are enforceable by the court. We can see constitutional remedies, Supreme Court can issue the writs in case of violation of fundamental rights, but that's not the case in the case of DPSP policies. They are not enforceable by the court. We cannot ask for the establishment or to follow the guidelines of DPSP policies. Fundamental fundamental rights are like command to state. These are the commands for the states, and DPSP policies are not directly command for the state. Next, a law inconsistent with fundamental right is void, and a law inconsistent of DPSP policies cannot be void. I will quickly tell about the socialistic principles. So they are the principle that aim of providing social and economic justice and a path towards the welfare of the states. Under various articles, they can direct to the state. Like in Article 38, they protect the inequalities in case of income, status, facilities and opportunities. And in Article 39, they can protect the DPSP policies, protect the rights of the citizen to provide the adequate means of livelihood, equal distribution of material resource, prevention of concentration of wealth and means of production, equal pay for equal work for men and women, preservation of health and strength of workers, and opportunity for healthy development of children. Next is Gandhian principle. This is the second classification of the DPSP policies, and these principles are based on Gandhian ideology to represent the program of reconstruction, and this the vision of, they protect the vision of the Gandhiji. And the Gandhian principles are mentioned in the Article 40, 43, 43B, Article 46, 47 and Article 48. And the third is liberal intellectual principles. So these principles reflect the ideology of liberalism under various articles, and they direct the state for the uniform civil code, they protect the environment, and they provide the guidelines for the environment. This is mentioned in Article 44, 45, Article 48, 49, Article 50 and 51. So I have completed, I have discussed the topic about the fundamental rights and the DPSP policies. Thank you very much.